How do I file an affidavit of heirship? Have you ever wondered how to navigate the process of filing an affidavit of heirship? This document can be a helpful tool in estate planning, especially when trying to avoid the formal probate process. Let's break down the steps to make this process as smooth as possible. First, you will need to gather all necessary information about the deceased person. This includes their full name, date of birth, date of death, marital status, and family history. You should also identify all heirs who are entitled to inherit the property, like children, a spouse, or other relatives. Additionally, include details about the property involved and any debts or claims against the estate. Next, prepare the affidavit document. This should be a written statement that clearly describes the family history and genealogy of the heirs. It must state that the deceased died without a will, which is known as intestate, and that the listed heirs are the rightful successors. Often, a knowledgeable family member, close friend, or attorney familiar with estate law will prepare this document. In many states, the affidavit must be signed by one or more disinterested witnesses. These witnesses should personally know the family history and can attest to the facts stated in the affidavit. They will also need to swear to the truthfulness of the affidavit before a notary public. Once you have the affidavit signed, it is time for notarization. This means the affidavit must be signed in the presence of a notary public or another authorized official. The notary will acknowledge the signatures and notarize the document, which is essential for giving the affidavit legal effect. After notarization, file the affidavit with the county recorder or appropriate office where the real estate is located. Recording the affidavit makes it part of the public record and establishes the heir's ownership rights. Once filed, the affidavit serves as prima facie evidence of heirship. This means it can be used to update property titles, allowing heirs to sell, transfer, or manage the property without going through formal probate. However, keep in mind that this process is generally limited to real estate and may not apply to bank accounts or other financial assets, which might still requiring probate or other legal procedures. If there are any disputes among heirs or challenges to the affidavit, a court may requiring a formal heirship proceeding to determine legal heirs. In cases where there is no disagreement, the affidavit process is a simpler and less expensive alternative to probate. From the perspective of elder law and estate planning, filing an affidavit of heirship can be an effective way to avoid the delays and costs associated with probate. This process helps protect the rights of heirs and facilitates a smoother transfer of property ownership, which is especially important for elderly individuals and their families managing estate transitions. By following these steps, you can successfully file an affidavit of heirship and navigate the estate planning process with greater ease.